Have you heard the latest alarming headlines or seen those viral posts on social media about U.S. visas suddenly shutting down overnight? Maybe you're feeling that knot in your stomach right now. The fear, the confusion, the uncertainty of what this means for your future, your family, or your job here in America. I get it completely. These moments can feel overwhelming and scary, especially when rumors spread so fast. But you're not alone, and you're in a safe place here. At Immigration Path USA, we cut through the noise with clear, honest facts. No hype, no fear-mongering, just reliable information you can trust to make sense of it all. Please subscribe to Immigration Path USA for the latest updates about immigration news and changes, so you can stay informed with accurate and reliable information. Today, we're talking about three critical updates that are making waves. The expiration of the religious worker visa category tonight, January 30th, 2026. New USCIS guidance on hold and release procedures. And the recent boost to self-deportation incentives through the CBP Home app. Let's break this down step by step, calmly and clearly, so you know exactly what's real, what's happening, and what it means for you. Remember, this is general information based on official sources. It's not personal legal advice, so always check with a licensed immigration attorney for your specific situation. First, the SR Religious Worker Visa, officially the employment-based fourth preference certain religious workers category, often called the SR visa. This is not a rumor or a sudden ban. It's a scheduled expiration built into the law itself. According to the January 2026 Visa Bulletin from the U.S. Department of State, this category expires at midnight tonight, January 30th, 2026, which means after 11:59 p.m. Eastern Time on January 29th, no new issuances or status adjustments can happen under SR. This has been in the Visa Bulletin for weeks, announced back in December 2025, so it's not a surprise or a political move. It's the sunset provision in the immigration law that Congress set years ago. Religious workers in this category, like non-ministers or certain support roles at nonprofits, could previously apply for green cards through EB-4, but that window closes tonight unless Congress acts to extend it, which hasn't happened yet. Let me correct some misinformation I've seen floating around on social media and WhatsApp groups. No, this doesn't affect all religious workers or EB-4 visas broadly. Ministers still have their own path, and other employment-based categories are moving forward per the February Visa Bulletin preview. Claims that USCIS is canceling existing approvals are false. If you already have an approved petition before tonight, check your priority date and consult an attorney about options like porting to another category. And please avoid anyone promising quick fixes or fake extensions. These are scams that prey on worry. What should you do? If you're in this category, gather your documents now, contact your sponsoring organization, and reach out to a licensed attorney immediately to explore alternatives like R1, non-immigrant status, or other EB visas. Lawful permanent residents and U.S. citizens are protected here, as this is just one narrow employment-based lane. Next, USCIS guidance on hold and release procedures. This is an actual enforceable policy update issued this month by U.S. Citizenship and Immigration Services as a memo to their field offices. It's not a new law or a draft. It's official internal guidance on how to handle certain pending cases from high-risk countries, including asylum applications, benefits like TPS or DACA renewals, and even diversity visa lottery winners. Under this, USCIS can place cases on hold during enhanced vetting and release them once cleared. Importantly, nothing has changed overnight for applicants. Your filing deadlines and eligibility rules stay the same. This is just procedural, aimed at national security reviews that have been standard for years. I've seen social media posts claiming this means automatic denials or mass pauses. That's not true. For example, proposed policies under the Trump administration have discussed stricter vetting, but this USCIS memo is already in effect and applies only to specific cases flagged for extra checks. If you're waiting on an asylum interview or DV results, keep monitoring your USCIS account online and respond promptly to any request for evidence. Don't panic and withdraw applications. That could hurt your status. Instead, stick to official USCIS.gov updates. And if your case is affected, a qualified immigration lawyer can help track it and advise on waivers or appeals. Maintaining continuous lawful status is your best protection, and green card holders should feel secure as these procedures don't retroactively impact approved residencies. Finally, the DHS update on self-deportation incentives. This was officially announced on January 21st, 2026 by the Department of Homeland Security through U.S. Customs and Border Protection. They've raised the incentive to $2,600 for individuals using the CBP Home app to voluntarily depart the U.S. instead of facing removal proceedings. This app, launched last year, lets people report their departure plans electronically, avoiding detention and getting financial help for travel costs. It's not a trick or a trap. It's a real program for those already under final deportation orders or voluntary return agreements. Social media has twisted this into claims of forced apps or citizenship penalties. Not accurate. This is optional, targeted at people without viable relief options, and it doesn't affect those in valid visa status, green card holders, or citizens. Rumors about it applying to H-1B workers or students are baseless. If this might apply to you, download the app from official sources, read the terms carefully, and speak with an attorney before acting. Self-deportation has serious reentry bars, like 3 to 10 years depending on your case. For everyone else, this is just one enforcement tool in a bigger picture. Focus on complying with your own status requirements. Throughout all this, remember, immigration laws don't flip like a switch. Changes start as political discussions or proposed bills, go through Congress or agency rulemaking with public comment periods, and only become enforceable after publication in the Federal Register. What we're seeing here, the SR expiration, USCIS memo, and CBP incentive, are all official published steps, not drafts or hype. Always go to uscis.gov, state.gov, or dhs.gov for the truth, and rely on AYELA-listed attorneys, not random online advisors. If you're a student on F1, a worker on H-1B, a family with an I-130 pending, or pursuing citizenship, these updates might feel distant, but staying informed protects you. Lawful status gives you time and options. Use it to plan ahead. Citizenship offers the strongest shield against policy shifts, so consider naturalization if eligible. Thanks for watching this urgent update on Immigration Path USA. If this helped clarify things or ease your mind, please like the video, subscribe, and hit that notification bell so you never miss reliable news like this. Share it with friends and family who might be worried. Your share could prevent panic or scams. Drop a comment below. What's your biggest question about SR visas, hold and release, or self-deportation? Or suggest topics for our next video. We're here for you. Stay safe, stay informed, and take care.